following program is classified G. It's suitable for all ages.
Tonight, how can Sri Lanka tackle financial fraud in the 21st century? As the country expands its economic interests, the importance of securing finances through well-structured legal frameworks have come up. The Securities and Exchange Commission Act, which is one of the foremost pieces of legislation designed to protect investor interest, has been modernized under the new administration. But what are the new provisions that the new act has identified? Will this be adequate in the status quo? Welcome to Law, Land and Liberty, where we are keeping with the promise of bringing in a contemporary legal topic and breaking it down in the midst of an expert in that field. Today, we are going to discuss something that is very much pertinent to the markets, to the growth of the economy, and to securing the finances within this country. And something that was a recent development within the law within this country. And we have with us an expert to give us a breakdown of that specific subject, which is going to be on the Securities and Exchange Commission Act of 2021. And the person that is going to discuss and really break it down for us is the chairman of the Securities and Exchange Commission of Sri Lanka, President's Counsel, Viraj Dayaratne. Thank you so much, sir, for joining us today. Before we go into the discussion, we give us general breakdowns for our viewers so that we know where the discussion is going to head and where exactly they can get the understanding of which portion that a viewer would have a question with. So firstly, we are going to talk about the salient features of the new act and we'll get a breakdown as to where the important aspects are located, where the updates are, where the amendments have been made. Secondly, we are going to talk about the role of the Securities and Exchange Commission, which has been updated where the developments and advancements have been. Thirdly, the offences and actions pertaining to the market misconduct that can be taken, things like insider trading and those aspects that have been within the forefront within the public forum for quite some time. And finally, on market development and the aspects within the act that have allowed for market development to proceed.
Hello, my name is Dhananjay Pereira and I'm a marketing executive. My question is about the features of the new SEC Act. What are the salient features that may provide a novel outlook from the SEC Act?
All right, let's move directly into the discussion. President's Counsel Viraj Dayaratne, thank you once again for joining us on this very much important topic, something that the people really need a clarification on. Now, the majority of people that we're speaking to right now will be the laymen, the people that are engaging in the market, will be looking at new investments, will be looking at bringing in foreign investors, but may not be too well versed with the legal framework that is behind all of this. So before we get into any details, Mr. Viraj, I want to get your take primarily on, now there's a new act and this has been amended quite a few times. And I believe from the 1980s, this has been coming in, advancing, evolving for quite some time. Within 2021, what are the key features that you see? Where is the breakdown? What sort of picture can you draw pertaining to this new act?
Well, the act that we had initially was brought in 1987. So it was 30 years old. Yeah. So the requirement for a new act was felt for a long time. Actually, the process of drafting a new act had commenced, I am told, in 2008. And several drafts have been prepared, but it had not been taken to a finality. We didn't see a new act being brought in. Mm-hmm. So we are happy that finally the government took steps to enact this law, Act number 19 of 2021. So what was required was our market has evolved from actually formal trading commenced in 1985. Then we saw the stock exchange being set up. Then we saw the Securities and Exchange Commission being set up. So we have come a long way. Our market has evolved. So it was necessary for us to have a proper legal regime. Yeah. A legal regime that would be relevant to the present context. We had to change with the times. We had to ensure that our legal framework was in line with other jurisdictions, that the standards that are expected of a capital market are incorporated into our law. So that is why a new act had to be brought in. And I would say, Dhanindu, it addresses regulation as well as development of the market.
Okay.
So we could have a robust regulation, as well as there are features that would enable the development of the market.
Market as well. Mr. Viraj, quite a few things I want to clarify on our first segment, but before we get into anything extensively, from what you have seen now, the discussion when it comes to the specific program, also most of the time we see, okay, the laws are a little predated, some needs to evolve much more, but this is in 2021, and this is in a field that is evolving. The legal fraternity has taken a lot of interest, and the monetization, the commercialization aspect is quite high. Where would you point and say, okay, these features are what is most important, these are the things that require the most amount of evolution, and we have gotten there as of now with this act?
Yeah. So if you take the regulator, I mean the Securities and Exchange Commission,
yeah.
Our responsibility is to ensure that there is a fair market. There's a fair market, and that there will be investor protection, as well as we have a twin role to ensure the development of the market. So that is where it was necessary to ensure that the regulator had the necessary powers to ensure that to ensure the integrity of the market, to ensure that all market participants are able to engage in their activities in a particular manner, and that the investors' interests will be looked after. So that is the prime most concern as far as the regulator is concerned. And as I told you, we have to balance that with the other function of enabling the development of the market.
I think it's very interesting when that is pointed out. We'll take that within our last segment as well, Mr. Viraj, because what generally, when someone says SEC, it's more or less like a policeman's role where it's looking at it. But now you mentioned, there's a development aspect involved in this. We'll extensively talk about it. But before going there, I want to pick on something you just mentioned about investors. Now, foreign investment, FDI, a word that has been spoken of regularly these days, and we are looking for it. Almost all Sri Lankans looking forward towards the development of the country are really looking at how to improve the foreign exchange within this country. Mr. Viraj, how does the identification between a foreign investor and a domestic investor, that demarcation be made, and what are the rights or what are the specific guidelines given to either of those parties? Because we are looking forward for investors coming from other countries, and now it's a very positive sign to see that we have taken steps to update our law in this year itself. How does that demarcation happen, if I may ask, like foreign investment and a domestic investor?
Yeah, well, there is no distinction when it comes to investors, whether you are a domestic investor or whether you are a foreign investor. There is no actual difference. All investors will be treated alike. Well, what's important is to protect the investor, be it a local investor or a foreign investor. Let me tell you one anecdote. We were in Dubai recently on an investment promotion drive, and we happened to go to Abu Dhabi to meet with the chairman of the Abu Dhabi Chamber of Commerce. Okay. And I think just about 2 or 3 minutes into our conversation, what he asked us was, what laws do you have for investment protection? Okay. Right? So you see, as when you talk of foreign investors, it is essential that we have a legal regime that has provision for the protection of investor. So that is why I said that is the prime most task of the regulator, to ensure that the investments of investors, be it foreign or local, are protected. So when it comes to foreign investors, if you are to woo individual investors or foreign funds, the importance of having a proper legal regime becomes of paramount importance, because they will want to know what provisions we have in our law for the protection of investors, how do the market institutions function, how do the market intermediaries function. So they need to be satisfied with all of that in taking a decision whether to come to our market. So that is why it is important to have a proper legal regime.
All right. Mr. Viraj, if I may ask, when you do go abroad and when, one of the most important missions would be to bring in investments in those regards. What are our unique selling points when it comes to the legal field, specifically when it comes to the specific act that has been that the Parliament passed? Where do we say, okay, these are the concrete steps we are taking to protect investment. This is how we are maintaining a secure capital market. I want to move into the stock market also and really talk about how the Securities and Exchange Commission involves itself there and the updates basically. But what are those unique selling points? What do you go and say, okay, look, these developments we have made, we are confident about this will be implemented?
Yeah. So, Danindu, that is where in the Act, you can't simply say our Act enables the protection of investor. Yeah. They will want to know how. Yeah. Right? So that is why the previous Act that we had was contained only about 50 or some 52 or 53 sections. Okay. But the present Act has 189 sections. So all matters are dealt with. Okay. How the role of the SEC, the role of the market operator, that is the exchange, how an exchange can be set up, the duties and functions of a market operator, the market intermediaries, how are they regulated, what are their duties and obligations. Then when it comes to settlement, it's important to ensure that post-trade settlement, there is a proper mechanism to ensure that there is no post-trade settlement failure. Right? Then what are the other steps that we have with regard to trading, the facilities for trading, the infrastructure we have? So those are the selling points. We'll have to show that ours is a frontier market, no doubt, but we have all what is required of a frontier market, and that this is a place to come and invest. And also, as far as investments are concerned, the fact that they can enter and exit without any issue. Smooth. So those are the factors, I would say, that a foreign investor will look at.
In terms of accountability and in terms of whether the act gets implemented, since you are within this regulatory authority, you're heading it for quite some time, where do you think are the vacuums, and has those vacuums been addressed with this act? Has there been vacuums is my first question, and where are we in that regard?
Yeah, so I think people particularly may not want to be told that they can be regulated to a great extent, because most often when you talk of laws that will help better regulation, people get a little scared.
People don't like
they think that we will, as you said earlier, that we will act like a policeman and be after you all the time. Well, that is not what is expected of a regulator. Regulator has to ensure that the market functions the way it ought to function, and that each one of the market participants are able to engage in their affairs without a hindrance. But they will have to act according to law. Right? They ought to know what is prohibited conduct and what is permitted conduct, and they should get about their tasks in the way it ought to, according to law. So that is what I would like to emphasize. And the present act gives us the regulator the necessary space, the necessary, as well as the necessary powers to ensure that things happen the way they ought to happen. Right. So that doesn't mean that all those powers will have to be used. What can be done will be stated in the Act, but as to when and how you use it is a matter to be determined by the regulator, and the regulator will have to use those powers in a way that will not hinder the activities of the market.
Based on those situations as they arise.
You have to exercise your powers according to the requirement.
Okay, I think a very good start there, Mr. Viraj Dayaratne, President's Counsel. We'll take a very short break and we'll come back and we'll discuss the role of the Securities and Exchange Commission, how it has been updated, where it is right now. Stay with us on Law, Land and Liberty.
Hello, my name is Vishwini Masha and I am Consumer Engagement Executive. My question is about the role of the SEC. Does the Securities and Exchange Commission have a prosecutorial role?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel Viraj Dayaratne, who is the chairman of the Securities and Exchange Commission of Sri Lanka. Mr. Viraj, I think a very important segment that we passed, which gave a little bit of context to the new act. Now, I think something that was mentioned in passing within our first segment was the role of the Securities and Exchange Commission. As the head, if I were to ask you very abruptly, where do you see the developments? Where has it been made easier for you to basically do your job in these markets? Because my next few questions are going to be related to the stock market. How has that update been made?
Yeah, so I would say the new act enables the regulator to engage in its function in a manner that will ensure consistency and predictability. Okay. Because that is very important for market participants to know how regulation will take place. Mm-hmm. Now, as I said earlier, the act deals with all aspects. There are 7 parts, which in turn are divided into several chapters. Yeah. So all aspects are dealt with in the act itself. Danindu, there are rules that are made in terms of the law. There are regulations that are made. Then you find the market operator also has its own rules. Okay. So all of that is contained in different parts. Okay. But now what has happened is most of it is contained in the act itself. Mm-hmm. So that is why I said there is predictability, there will be consistency, because you know how a particular thing will be done. Okay. Let's say the licensing procedure. If you take the market institutions, the exchange, the clearinghouse, and the CDS, then you have the market intermediaries, you have supplementary service providers, as to how they will be licensed, how they will be disciplined, in the sense how oversight will and can take place, what sanctions can be attached. All of that is now very well known, and one simply has to turn to the act to find out how that will happen. Okay. So that is a significant change that we see in the present law, which we didn't see in the previous act.
Mr. Viraj, in assessing, because you had to come to the media and speak about this when the act came about, you did mention that every section had a preamble with where exactly the act was going with that section, the objectives of the act. If I may ask you, the Commission, what are the revamped objectives? Where do you, because all of our institutions currently we have seen, within the country, they have a sort of long-term plan that they're trying to implement, trying to bring in certain objectives for their own organizations. Where does the Securities and Exchange Commission want to position itself as a body within this country now that things like the port city, things like investment zones in Hambantota are coming up? Where do you position the Securities and Exchange Commission within the next few years?
Yeah. So you spoke of the objects and purpose. Well, part 1 speaks in great detail about the objects of the act and the powers and functions and the duties of the regulator, the commission. Yeah. But you are right, in the different parts, as I told you, there are 7 parts. Yeah. Each part begins with the objects and purpose clause. Yeah. So that sets out what is sought to be achieved under that particular part. Now that is a healthy development, because the reader, anybody looking at the law, will know what is sought to be achieved under that particular part. Yeah. Then you asked me how we would like to position ourselves. As I told you earlier, the regulator's role primarily is to ensure the fair and orderly market. Mm-hmm. So in order to ensure a fair and orderly market, we have to ensure, as I said, one of the tasks is investor protection. Then that the market operator performs its functions properly, right? That's the exchange. So there is provision under the new law to have more than one exchange. Mm-hmm. Well, you spoke of the port city. Mm-hmm. Yes, it is possible that we could have maybe a separate exchange in the port city, okay, right? So the port city, the law, Port City Act also envisages the setting up of maybe an exchange, then various other regulatory matters that the Port City Commission may be entitled to do in addition to the Securities and Exchange Commission, right? So we have to be mindful of how our market will evolve, right? And there will be more responsibility on the part of the regulator. So that is why I said the new act enables us to regulate in a manner that will ensure that the market will be the activities will happen in a proper manner, and if there are any breaches, if there are if there is any action that will impede the proper functioning of the market, as to how as the regulator we can intervene and stop such activity. So that is where I'm sure you will come to those matters later.
Yeah.
But as to what the offences are, how we could deal with such activity and so on. So we see, I mean, our market, you would have seen how it has developed over the last 2 years.
Yeah.
It has performed
in the last few months, actually, we have been performing really well.
Right.
Yeah.
So we have to know where we are heading. There's a lot of scope.
Yeah.
The Act has a lot of features, as I told you, for the development of the market. So we want rather to take our market to the next level, probably to take it to the level of an emerging market. So we are working towards that. And as I said earlier, we have this twin responsibility. You would have seen from our conduct that we have not only been keen on the regulatory aspect, but we have taken a lot of steps that will help develop the market.
As a final question for this segment, something I want to ask you now, when I browse through the Act, something that we notice is we are pointed towards different other acts, for example, the Bribery Act or even the Computer Crimes Act, if I'm not mistaken. Is this the fundamental law when it comes to financial security within our country? Or should we be aware of other tertiary aspects? I believe you mentioned this act specifically expanded the scope, was quite comprehensive. So if we are to refer to, if a foreign investor is to come here and look at the legislature, the law that is present for securing their own investments, is this the primary place they need to go to, Mr. Viraj, or will you have to point them to, okay, look, these specific things are in direct attachment to this act, the functioning of the Securities and Exchange Commission Act will depend on the following as well? How would you phrase that?
Yeah, well, if anybody wants to know what is the law that governs the capital markets in Sri Lanka, this is the law that you'll have to look at. That is why I said the law now deals with all aspects. So everything you need to know, you will find in this law. Of course, there will be the rules and regulations and the rules made by the market operator, the stock exchange. All of that is there. But if you want to know what the primary law is, it is the Securities and Exchange Commission Act. Okay. But of course, the Electronic Transactions Act, the Terrorist Financing Act, and so on, that prevents certain crimes being committed, will in an indirect way also become relevant.
Okay. Before we move into a break, Ms. Viraj, something I want to clarify with you, since you mentioned the Electronic Transactions Act, and that is something that we discussed here last week. Something I want to clarify is this. Now, we had Dr. Asanga come here and also talk a bit about the doing business index within this country and where we are positioned there. In relevance to the Securities and Exchange Commission, where do you see to do your role better, to sort of emphasize your role? Are we making equal developments in other areas, such as the electronic transactions part of it? Because most of these transactions, which have been happening for quite some time, is online. Is e-commercial sort of aspect, and the outsourcing of production really brings together only service centers to some areas, and then that would be where Port City comes into play. Are we making those similar developments in those areas as well? Where do you think you have seen important strides, maybe not coming to the SEC, but in other areas of law that require those developments?
Yeah, well, into the Electronic Transactions Act has been here in operation for a long time. It's just that its provisions have not been made use of. But I'm happy to say the government is also giving a lot of importance to digitalization. So most of the provisions in the Act are now being used. Okay. Let me tell you, we spearheaded the digitalization of the end-to-end operations of the stock market. So that is where we made use of the provisions that are there in the Electronic Transactions Act with regard to the opening of accounts, the verification of KYC, the Know Your Customer, the details. So you would have, I'm sure you are aware, the opening of an account can happen within minutes. You can on the go or in the comfort of your homes with the use of your mobile telephone, you can open a CDS account and straight away start trading. Now that is possible not only for those in Sri Lanka, even for those Sri Lankans who are living outside. The companies who want to open an account, again we have facilitated that, because previously one had to go to the register of companies, provide those details, and physically you will had to attend to those tasks. But all of that can now happen electronically. So I don't want to give details, but we have the stock market is now functioning. The curfews or restriction in movement doesn't affect the operations of the stock market, and the functions that take place presently, you'll be surprised if you were to look at the list of things that can be done electronically. So I think we have taken a lead in giving this example to others to follow.
Yeah.
And that's what we have been we have explained during our recent visit to Dubai. We had this forum, how even foreign clients can now open an account and start trading. Things have got very much easier. So that is where we have made use of the legal provisions that are presently available. So as I said earlier, Danindu, it's a question of making use of those provisions. Not a question of the laws, the facilities, or the laws not being here.
Okay. I think just before we go into a break, I want to ask this one question. This might be stepping out of the ambit of the law for a while. How has the reception been? Because now even like I was capable of getting the app, and the process is far more streamlined. It's smoothened, it's ironed out. In terms, but we are not aware of how well has this been received. What are the number of accounts that have been? If you have the details, please share with us. But if not, what sort of reception have you seen from investors, from domestic, the youth that are getting involved in all of this? What has the reception been like?
Well, reception have been very encouraging. I think over 40,000 new accounts have been opened, online opening of accounts. There have been over 100,000 downloads of the CSC app. And one other encouraging factor is that those who have opened new accounts are those below the age of 40. So you can see the youth is interested in the market. So it was because of digitalization that we were able to achieve that. And since trading has become easier, the daily number of trades, which used to be in the range of about 5,000 or 6,000 in 2019, now goes some days up to 60,000 trades a day. So you can see the interest, how it has been received.
Yeah. I think a very positive sign there. We have to discuss a bit more pertaining to this subject. We'll take a very short break.
Hi, my name is Dayaratne. I'm a student at Sri Lanka Law College. My question is about action against offences. My question is, what are the legal remedies available for market misconduct?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel Viraj Dayaratne. Mr. Viraj, the advancements we have made within this discussion are really pointing towards the next most key segment now. The words such as insider trading, market manipulation, things like that have been thrown around for quite some time. And again, key things that are, whether there's money being laundered, the registration of individuals who are making investments, things that the Securities and Exchange Commission, one would say the crux was things that you had to be aware of. Within this act, I don't want to take much of your time, but within this act, how are these offences identified? What are the new developments we should be aware of?
Yeah. So you have what is generally called market manipulation.
Yeah.
That is what manipulation that could due to certain activities, how manipulation could take place in the trading of shares. Okay. On the other hand, we have insider trading as to who could commit insider trading, connected parties, and how that becomes how the conduct of certain parties could result in the commission of the offence of insider trading. Now, previously, according to the 1987 Act, it was called insider dealing. That was dealt with in the Act itself. But as far as market manipulation, certain aspects of market manipulation, the offences were spelled out in the rules, rules made under the Act. But now there is a separate part dealing with market offences, the main market offences under Part 5. And there are two. It has been separated into two categories under two chapters. What is known as prohibited conduct. Under prohibited conduct, 5 offences have been identified. And then in Chapter 2 of Part 5, insider trading has been dealt with in great detail. Okay. Now, if you take under prohibited conduct, under the 5 offences that have been spelled out, I would say what is important to note are the offences that have been spelled out under sections 130 and 131. Okay. I will briefly advert to that, Danindu. Yeah. 130 actually precludes a person from making a statement or disseminating information that is false or misleading in a material particular which is likely to have an effect of raising or lowering the market price or volume of securities. Now, you see a lot of views being expressed on social media. Yeah.
Particularly, it has a direct influence on this,
yes, particularly in view of the restriction in movement. Now, actually, social media has overtaken the traditional media in this country, and we see a lot of ideas, a lot of views being expressed. So, one has to be a little cautious now in view of Section 130. That again, it's not trying to muffle the freedom of expression, but one has to be a little
accountable,
careful. So that is what 130 deals with, and 131 Danindus precludes a person from inducing or attempting to induce another person to trade by making or publishing any statement or by making a forecast that is misleading, false or deceptive. Okay. So there again you have these ingredients. One has to get caught up in these the conduct that is prohibited if it were to become an offence. Okay. So these are 2 offences that I would like to highlight, particularly in the present day, because one has to be mindful of the consequences. Because, as I said earlier, it's not a question of trying to curtail the freedom of expression, but as you know, every right entails an obligation. True. Right? So, this is one aspect that one, I would say, has to be a little
I think
careful.
that accountability aspect is quite important, especially within this country, pertaining to what people say. Before you move into insider trading, Mr. Viraj, I want to ask you, I think this also you had come to the media and really explained, and I'd like to get your take on this. Now, there's a civil and criminal aspect both to like the offences entailed in this, so it's a bit of a complex, complex number of offences that have been involved. Does the Securities and Exchange Commission play the role of a prosecutor? How does that work? How does the filing work? How, if there is reliable evidence, where do you proceed from that point on?
Yes. So the SEC is empowered to conduct its own investigations. Now, as you know, if it is any other criminal offence, it's the police that will conduct the investigations. But here, as far as capital market offences are concerned, whether be it the prohibited conduct that is identified under Part 5 or insider trading, it will be our officers. We have a separate investigations division. We conduct our own investigations. So it's a very thorough process. It's not that we just look at something and decide that yes, offence has been made out and that we will take some step. No, that is not how it happens. There's a tedious process of conducting an investigation, and then the investigations division submits a report. That report will spell out what the evidence, what the available evidence is. And once that is made available to the commission will go into the matter, look at the evidence that is available, and make a call. Will decide as to whether an offence has been made out. So if an offence has been made out, Danindu, now in terms of the new act, previously what we could do was to forward criminal charges.
Okay.
But under the present law, it is possible, taking into consideration certain circumstances, we could even file a civil action.
Okay.
Right? So that is in the Commercial High Court, the High Court that exercises civil jurisdiction, what is commonly known as the Commercial High Court. We could go to the Commercial High Court seeking to recover damages or compensation, as well as the court is entitled to impose a civil penalty. Right? So the circumstances under which such a step could be taken, that is the filing of a civil action, is possible, is specifically stated. On the other hand, as far as filing criminal charges is concerned, now it will be in the High Court. Previously it used to be in the Magistrates Court. Now the sentences have been, the punishment that can be imposed has been enhanced to act as a deterrent. Then you ask me, how will that happen? How will the institution of proceedings happen? Well, if it is civil proceedings, the Commission itself can go to the High Court and institute proceedings, like how any other action is instituted in the Commercial High Court. But if it is to be criminal charges, as before, now previously when criminal charges were to be filed in the Magistrates Court, the Commission decides. So there is no change in how that happens. The decision to forward criminal charges is taken by the Commission, and once the Commission decides, then as you know, criminal charges have to be instituted by way of an indictment in the High Court. So according to the Criminal Procedure Code, it's the Attorney General who is empowered to file an indictment. Of course, there is one exception, the Bribery Commission is able to file an indictment. So we will then refer the matter to the Attorney General to forward an indictment. So that's how the process takes place.
Before we go into the insider trading aspect, Mr. Viraj, just to ask a very subtle question, what is the process, the time frame for these processes? Like, is it expedited under this act, or are we still seeing certain delays? Because these issues need to be clarified quickly, and if an investigation, unless it's not a complex issue, if it's something that can be settled, do you still see a delay in judgments being made? What is the situation like that? Well,
Danindu, timely action has to be taken. If these some punishments that have been brought in, if the new aspect of being able to institute civil proceedings, if they are to be meaningful, timely action has to be taken. Yeah. Because what we are seeking to do is to ensure that it acts as a deterrent, right? So it is essential that we take steps fast. But unfortunately, at the same time, we have to ensure that the matter is looked into properly. Yeah. That you can't simply, to speed up things, you can't do a half-baked investigation. Yeah. So you have to, there's a lot of trading, the analysis has to be done, right, which may take some time. To tell you very frankly, there have been delays in the past, and we are taking every step, every endeavor is being made to ensure that those investigations are completed fast, and if there is evidence, we will institute proceedings. So the aim of the present commission is to ensure that investigations are done in a timely manner, and that the decision as to whether charges could be forwarded or not has to be taken fast.
Before we move into a break, I need to give you some time to speak about insider trading. Within this act, I think you really pointed out two key areas when it comes to the expression of misinformation and fraudulent statements being made, which is quite damaging to the people that are engaged, who are honestly engaging in these markets. In terms of insider trading, are there any developments pertaining to the 1980s Act 87, or is it Are there new developments, or should we be concerned about these areas? Where do you see important things to highlight?
Yeah, so as I said earlier, insider trading is a distinct offense,
Yeah.
right, as opposed to market manipulation.
Yeah.
As to how insider trading can happen, now that is spelled out under section 137, 1 and 2,
Okay.
right? So the difference is, Danindu, now under the new law, there is a separate chapter. Chapter 2 of Part 5 deals entirely with insider trading. So as to what a person is prohibited from doing, right? What information is, there is a definition.
What
right?
information is, okay.
What information is, when information is generally available has been explained. Information which has a material effect on price and value of securities, what that constitutes, has been explained. What procuring or counseling a person to commit the offense has been very specifically explained. When information is deemed to be in the possession of somebody has been explained, as well as, very importantly, what the exceptions would be,
Okay.
have been very clearly explained, and what defenses are available to a person who is accused of committing the offense of insider trading has been explained in great detail.
Okay.
So there cannot be any doubt as to whether an offense has been committed or not. So that is what is very important, Danindu, and that is a very that is a development then we can all be happy about.
All right. Again, a number of things I want to ask you, but we'll go in for a very short break and we'll come join us on the last segment where we talk a bit about how the Act enables the development of the market. You're with Law, Land and Liberty. Stay with us.
Hello, my name is Imeshi Sahabandhu. I am a manager for a local conglomerate in Sri Lanka. My question is on market development. How does the SEC look into market development?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel Viraj Dayaratne. This is our last segment and we are going to focus on market development. But before we make that step forward, something I want to clarify and really give iron out for our viewers is evidence plays a huge role in all of this, and that traceability of evidence and the admission of evidence is something that has been improving over time. But does the Act speak about that, Ms. Viraj? And when it comes to the defenses, is it highlighted there? You know, what really, the fact that information has been really broken down is very important. Apart from that, electronic evidence, the admission of that, is that something that the Act deals with, or should we look elsewhere?
Yeah, let me first answer the last part of your question, whether the Electronic Transactions Act would help. Yes, it does help. In the presentation of evidence. Okay. So that is one. The Act specifically says that the provisions of the Electronic Transactions Act will apply.
Okay.
So that is a salutary feature. Of course, now you know it's important when you talk of evidence. It's also important to know what the ingredients of an offence is, because evidence has to be produced to support to establish the fact that those ingredients are available. To establish the commission of an offence, it has to be based on the ingredients. So as I told you earlier, the ingredients have been very specifically identified. So what we need to do is to find evidence to prove a particular offence, whether be it market manipulation or insider trading. So you have to understand, unlike other offences, these are white-collar crimes, and most of the time, the evidence we have is not direct evidence. Okay. Most of the time it's circumstantial evidence. So the task gets more difficult, right? So you have to lay before court the different items of circumstantial evidence and request court to draw inferences. Okay. Particularly you are keen to know about the offense of insider trading, as to how one got the information, what information you got, when you got that information. Only that person knows. We don't know. Right? How do we establish that? We have to establish that through the conduct of that person.
Okay.
So through the conduct, we'll have to place, as I said earlier, the different items of circumstantial evidence, and it has to be proved by inviting court to draw inferences. There is no other way in which these offences can be proved.
All right. An interesting clarification there. Before leaving that part aside, moving to this very specific segment of market development now, you addressed in the initial parts, and the term you used was with the policeman's role is what the SEC does, but you say that, look, there is a bigger role, there's a bigger objective here in play where enabling the market to develop and enhance themselves is something I think a majority of people wouldn't know about. Or how does the Act really look into this?
Well, the Act will enable the use of modern infrastructure. One example that I can give is, as I told you earlier, there are 3 market institutions that have been identified. One is a clearinghouse. Okay. That is where settlement of trades takes place. Now, the new Act envisages the setting up of a central counterparty. Now, that is where the central counterparty risk will be minimized. So, the Act envisages the setting up of a CCP. And you may have already heard, we have brought in delivery versus payment, DVP, in August of this year. That was a huge step forward. So the next step is, now we are closer to getting to the next step, which is the setting up of a CCP. And I'm happy to announce the SEC, the Commission, last week decided that we should set up a separate CCP for the capital market. So we will now work with the Colombo Stock Exchange and help them set up a CCP. So now that is possible under the new law. What a CCP has been specifically explained under the new Act. Then with the setting up of a CCP, it will enable us to introduce new products such as derivatives, futures and options, irrespective of the nature of the underlying asset. Then stock borrowing and lending can happen, regulated short selling can take place. So these are products that are necessary if you want to give investors a better option, depending on your risk return, depending on the risk return characteristics of those products. The investors will have an opportunity to invest in these new products that can be introduced. So now that is permitted under the new law. Then we can, it provides for a market maker, it recognizes who a recognized market operator is, it provides for market makers, then it enables various funds to be set up. They are under the category of collective investment schemes. So these done into are the developments that can take place in the future. It may not happen immediately, but this is a futuristic law. So it can, certain products can come in immediately. I don't want to give you a list. We have a line of products that we have in mind to be introduced in the near future. So maybe in the short term, in the medium term, in the long term, there are various products and developments that can take place.
Mr. Viraj, something that was very interesting for me as well when you said the introduction of new products. I think our viewers would also like to know this now when it comes to other markets, when it comes to foreign markets, the transactions that are based on futures are it's quite commonly seen when it comes to oil or when it comes to gold or something like that. How can such a product be introduced within markets within our country? Do we need private-public partnership in these scenarios, or can the SEC really take this forward?
Well, these are products that can be introduced in the capital market, okay, right? So we know how these things happen in other markets. So there is a way in which they happen. It's well known. Yeah. It's just that they have to be introduced to our market. And that's why I said you have to have certain facilities for that. You have to ensure that the counterparty risk is minimized. So that is why I said for certain products, it's essential that we have a CCP in place. So then we will introduce the legal framework within which these products can be introduced. So that is what can be done, Danidu, in terms of the new law. So that's why I said this law recognizes. Now, for instance, covered short selling, stock lending and borrowing, these were not envisaged under the previous law, but the new Act specifically identifies them. Okay. So these are products that are available in other markets. So our law now enables us to introduce them.
Okay. Mr. Viraj, before we end, the final question I have for you is, now when looking at this act, I think we really covered quite a bit of content. For investors who are still not sure about it, who are not clear, who have questions pertaining to whether we have a more ironed out process in play right now when it comes specifically to the Securities and Exchange Commission in securing their assets, their finances. What sort of message would you like to give to them? Where do you think the core of this act is? Where do you think we are heading? Is it something that you can really give some form of confidence to these people that are coming in?
Well, as I said earlier, it would sound repetitive, but as I said earlier, there are features that would protect the interests of investors. So that is something that investors have to be confident of, that their investments will be safe.
Yeah.
Then, Danindu, what is most important is creating awareness.
Yeah.
The investors ought to know what the capital market is all about, what investments they could make, how secure are their investments, how does the market work.
Okay.
So that awareness is essential, and one has to be cautious, right? So we have taken the lead that the SEC, although it may not be our prime function, we have taken we have turned to social media in a big way. We have our Facebook account, we have our YouTube channel, we have our Twitter account. So through that medium, we have been disseminating a lot of information about the capital market, what can be done, what should not be done, what protection is available. All of that has been done, and on a daily basis. If you go to our website and if you see the tweets that we make on a daily basis, so all of that, the creating awareness and educating the public is happening. What I would urge, Danindu, is for the public to make use of that information that is very freely available,
okay,
and make use of that, educate yourself, and then come into the market.
Right. A lot of important clarifications made there. I thank you a lot. The kind of time and the kind of resource that you have provided here is very important. The Chairman of the Securities and Exchange Commission of Sri Lanka, President's Counsel, Viraj Dayaratne, thank you so much for joining us.
Thank you for having me.
Yeah. All right. The future of finance will certainly open windows of opportunity that may be misused if not properly overlooked. Arjan Riernik, a doctoral researcher from the Max Planck Institute for the Study of Societies in Germany, studied the empirical evidence surrounding fraud in the world of commerce under a study titled Financial Fraud, a Literature Review. He concluded within the study suggesting that it is imperative to recognize the illegal dimension of behavior among financial market participants and to deepen our understanding of such behavior in order to further our understanding of financial market dynamics and to safeguard the integrity and soundness of financial systems in the future. The importance of securing finances goes well beyond investor confidence, but rather the entire outlook of the country's economy will be determined by it. That is all from us here at Law, Land and Liberty. If you had missed today's program, you can watch the entire episode on our YouTube channel, youtube.com/otherderana English. Join us again next week as we break down a contemporary legal topic. I'm Danindra Tanavasan. Have a great night.